I call on the Chief Prosecutor for Great Britain and Northern Ireland.
May it please the tribunal. On an occasion to which reference has and will be made, Hitler, the leader of the Nazi conspirators who are now on trial before you, is reported as having said, in reference to their warlike plans, "I shall give a propagandist cause for starting the war. Never mind whether it be true or not. The victor shall not be asked later on whether we tell the truth or not. In starting and making a war, not the right is what matters, but victory. The strongest has the right." The British Empire, with its allies, has twice, within the space of 25 years, been victorious in wars which have been forced upon it, but it is precisely because we realize that victory is not enough, that might is not necessarily right, that lasting peace and the rule of international law is not to be secured by the strong arm alone, that the British nation is taking part in this struggle. There are those who perhaps would say that these wretched men should have been dealt with summarily, without trial, by executive action, that their power for evil broken, they should have been swept aside into oblivion without this elaborate and careful investigation into the part which they played in bringing this war about. Vive victis. Let them pay the penalty of defeat. But that was not the view of the British government. Not so would the rule of law be raised and strengthened on the international as well as upon the municipal plane. Not so would future generations realize that right is not always on the side of the big battalions. Not so would the world be made aware that the waging of aggressive war is not only a criminal venture, not only a dangerous venture, but a criminal one. Human memory is very short. Apologists for defeated nations are sometimes able to play upon the sympathy and the magnanimity of their victors, so that the true facts, never authoritatively recorded, become obscured and forgotten. One has only to recall the circumstances following upon the last World War to see the dangers to which, in the absence of any authoritative judicial pronouncement, a tolerant or a credulous people may be exposed. With the passage of time, the former tend to discount, perhaps because of their very horror, the stories of aggression and of atrocity that may be handed down. And the latter, the credulous, misled by perhaps fanatical, perhaps dishonest propagandists come to believe that it was not they, but their opponents who were guilty of that which they would themselves condemn. And so we believe that this tribunal, acting as we know it will act, notwithstanding its appointment by the victorious powers, acting with complete and judicial objectivity, will provide a contemporary touchstone, an authoritative and impartial record to which future historians may turn for truth and future politicians for warning. From this record shall future generations know not only what our generation suffered, but also that our suffering was the result of crimes against the law of peoples, which the peoples of the world upheld and will continue in the future to uphold. To uphold by international cooperation, not based merely on military alliances, but grounded and firmly grounded in the rule of law. Nor, though this procedure and this indictment of individuals may be novel, is there anything new in the principles which, by this prosecution, we seek to enforce. Ineffective though, alas, the sanctions proved themselves to be, the nations of the world had, as it will be my purpose in addressing the tribunal to show, had sought to make aggressive war an international crime. And although previous tradition had sought to punish states rather than individuals, it is both logical and right that if the act of waging war is itself an offense against international law, those individuals who shared personal responsibility for bringing such wars about should answer personally for the course into which they led their states. And again, individual war crimes have long been recognized by international law as triable by the courts of those states whose nationals have been outraged, at least so long as a state of war persists. It would be illogical in the extreme if those who, although they may not with their own hands have committed individual crimes, were responsible for systematic breaches of the laws of war affecting the nationals of many states, should escape for that reason. And so also in regard to crimes against humanity. The right of humanitarian intervention on behalf of the rights of man trampled upon by a state in a manner shocking the sense of mankind has long been considered to form part of the recognized law of nations. And here too, this charter merely develops a pre-existing principle. If murder and rapine and robbery are indictable under the ordinary municipal laws of our countries, shall those who differ from the common criminal only by the extent and the systematic nature of their offences escape accusation. It is, as I shall show, the view of the British government that in these matters this tribunal will be applying to individuals not the law of the victor, but the accepted principles of international usage in a way which will, if anything can, promote and fortify the rule of international law and safeguard the future peace and security of this war-stricken world. Mr. President, by agreement between the chief prosecutors, it is my task, on behalf of the British government and of the other states associated in this prosecution, to present the case on count 2 of the indictment, and to show how these defendants, in conspiracy with each other and with persons not now before this tribunal, planned and waged a war of aggression in breach of the treaty obligations by which, under international law, Germany, as other states, had herself sought to make such wars impossible. And that task falls into 2 parts. The first is to demonstrate the nature and the basis of the crime against peace, which is constituted under the charter of this tribunal by waging wars of aggression in violation of treaties, and the second to establish beyond all possibility of doubt that such wars were waged by these defendants. As to the first, it would no doubt be sufficient just to say this. It is not incumbent upon the prosecution to prove that wars of aggression and wars in violation of international treaties are or ought to be international crimes. The charter of this tribunal has prescribed that they are crimes, and that charter is the statute and the law of this court. Yet, though that is the clear and mandatory law governing the jurisdiction of this tribunal, we feel that we should not be discharging our task in the abiding interest of international justice and morality unless we showed to the tribunal and indeed to the world the position of this provision of the Charter against the general perspective of international law. For just as in the experience of our own country, some old English statutes were merely declaratory of the common law, so we say this Charter substantially merely declares and creates a jurisdiction in respect of what was already the law of nations. Nor is it unimportant to emphasize that aspect of the matter. To emphasize it, lest there may be some now or hereafter who might allow their judgment to be warped by plausible catchwords or by an uninformed and distorted sense of justice towards these defendants. It's not difficult to be misled by such phrases as that resort to war in the past has not been a crime, that the power to resort to war is one of the prerogatives of the sovereign state, even that this Charter, in constituting wars of aggression a crime, has imitated one of the most obnoxious doctrines of National Socialist jurisprudence, namely post factum legislation. But the Charter is, in this respect, reminiscent of bills of attainder, and that these proceedings are no more than a measure of vengeance, subtly concealed in the garb of judicial proceedings which the victor wreaks upon the vanquished. These things may sound plausible, yet they are not true. It is indeed not necessary to doubt that some aspects of the Charter bear upon them the imprint of significant and salutary novelty. But it is our submission, our conviction, which we affirm before this tribunal and the world, that fundamentally the provision of the Charter which constitutes wars, such wars as these defendants joined in waging and in planning, a crime, is not in any way an innovation. This provision of the Charter does no more than constitute a competent jurisdiction for the punishment of what not only the enlightened conscience of mankind, but the law of nations itself had constituted an international crime before this tribunal was established and this Charter became part of the public law of the world. And so let this be said. While it may be quite true that there is no body of international rules amounting to law in the Austinian sense of a rule imposed by a sovereign upon a subject obliged to obey it under some definite sanction, yet for 50 years or more the people of the world, striving perhaps after that ideal of which the poet speaks, when the war drums throb no longer and the battle flags are furled, in the Parliament of Man, the Federation of the world, the people of the world have sought to create an operative system of rules based upon the consent of nations to stabilize international relations, to avoid war taking place at all, and to mitigate the results of such wars as took place. The first treaty was, of course, the Hague Convention of 1899 for the pacific settlement of international disputes. That convention was indeed of no more than precatory effect, and we attach no weight to it for the purposes of this case. But it did establish agreement that in the event of serious dispute arising between the signatory powers, they would, as far as possible, submit to mediation. That convention was followed in 1907 by another convention, reaffirming and slightly strengthening what had previously been agreed. These early conventions fell indeed very far short of outlawing war or of creating any binding obligation to arbitrate. I shall certainly not ask the tribunal to say that any crime was committed by disregarding those conventions, but at least they established that the contracting parties accepted the general principle that if at all possible, war should be resorted to only if mediation failed. Although the conventions are mentioned in this indictment, I'm not relying on them save to show the historical development of the law and its unnecessary, therefore, to argue about their precise effect, for the place which they once occupied has been taken by far more effective instruments. I mention them now merely for this, that they were the first step towards that body of rules of law which we are seeking here to enforce. There were, of course, other individual agreements between particular states, agreements which sought to preserve the neutrality of individual countries, as for instance that of Belgium. But those agreements were inadequate in the absence of any real will to comply with them to prevent the First World War in 1914. And shocked by the occurrence of that catastrophe, the nations of Europe, not excluding Germany, of Europe and of other parts of the world, came to the conclusion that in the interests of all alike, a permanent organization of the nations should be established to maintain the peace. And so the Treaty of Versailles was prefaced by the Covenant of the League of Nations. Now, I say nothing at this moment of the general merits of the various provisions of the Treaty of Versailles. They have been criticized, some of them perhaps justly criticized, and they were certainly made the subject of much bellicose propaganda in Germany. But it's unnecessary to inquire into the merits of the matter, for however unjust one might for this purpose assume the provisions of the Treaty of Versailles to have been, they contained no kind of excuse for the waging of war to secure an alteration in their terms. Not only was it a settlement by agreement of all the difficult territorial questions which had been left outstanding by the war itself, but it established the League of Nations, which, if it had been loyally supported, could so well have resolved those international differences which might otherwise have led, as indeed they eventually did lead, to war. It set up in the Council of the League, in the Assembly, in the Permanent Court of International Justice, a machine not only for the peaceful settlement of international disputes, but also for the frank ventilation of all international questions by open and free discussion. At that time, in those years after the last war, the hopes of the world stood high. Millions of men in all countries, perhaps even in Germany itself, had laid down their lives in what they hoped and believed was a war to end war. Germany herself entered the League of Nations and was given a permanent seat on the Council. And on that Council, as in the Assembly of the League, German governments which preceded the government of the defendant von Papen in 1932 played their full part. In the years from 1919 to that time in 1932, despite some comparatively minor incidents in the heated atmosphere which followed the end of the war, the peaceful operation of the League continued. And nor was it only the operation of the league which gave ground, and good ground, for hope that at long last the rule of law would replace anarchy in the international field. The statesmen of the world deliberately set out to make wars of aggression an international crime. These are no new terms invented by the victors to embody in this charter. They have figured, and they have figured prominently, in numerous treaties, in governmental pronouncements, and in the declarations of statesmen in the period preceding the Second World War. In treaties concluded between the Union of Soviet Socialist Republics and other states, such as Persia in 1927, France in 1935, China in 1937, the contracting parties undertook to refrain from any act of aggression whatever against the other party. In 1933, the Soviet Union became a party to a large number of treaties containing a detailed definition of aggression. And the same definition appeared in the same year in the authoritative report of the Committee on Questions of Security set up in connection with the Conference for the Reduction and Limitation of Armaments. But at this time, states were going beyond commitments to refrain from wars of aggression and to assist states which were victims of aggression. They were condemning aggression in unmistakable terms. In the anti-war treaty of non-aggression and conciliation, which was signed on the 10th of October of 1933, a number of American states, subsequently joined by practically all the states of the American continent and a number of European countries as well, the contracting parties solemnly declared that they condemned wars of aggression in their mutual relations or in those of other states. And that treaty was fully incorporated into the Buenos Aires Convention of December 1936, signed and ratified by a large number of American countries, including, of course, the United States. And previously, in 1928, the Sixth Pan American Conference had adopted a resolution declaring that as war of aggression constitutes a crime against the human species, all aggression is illicit and as such is declared prohibited. A year earlier, as long ago as September 1927, the Assembly of the League of Nations adopted a resolution affirming the conviction that a war of aggression can never serve as a means of settling international disputes and is in consequence an international crime, and going on to declare that all wars of aggression are and shall always be prohibited. The first article of the draft treaty for mutual assistance of 1923 read in these terms: the high contracting parties, affirming that aggressive war is an international crime, undertake the solemn engagement not to make themselves guilty of this crime against any other nation, and in the preamble to the Convention, to the Geneva Protocol of 1924, it was stated that offensive warfare constitutes an infraction of solidarity and an international crime. These instruments that I've just last mentioned remained, it's true, unratified for various reasons, but they're not without significance or value. These repeated declarations, these repeated condemnations of wars of aggression testified to the fact that with the establishment of the League of Nations, with the legal developments which followed it, the place of war in international law had undergone a profound change. War was ceasing to be the unrestricted prerogative of sovereign states. The covenant of the League of Nations didn't totally abolish the right of war. It left perhaps certain gaps which were probably larger in theory than in practice. But in effect, it surrounded the right of war by procedural and substantive checks and delays, which, if the covenant had been faithfully observed, would have amounted to an elimination of war, not only between the members of the League, but also by reason of certain provisions of the covenant in the relations of the non-members as well. And thus the covenant of the League restored the position as it had existed at the dawn of international law, at the time when Grotius was laying down the foundations of the modern law of nations. And it established the distinction, a distinction accompanied by profound legal consequences in the sphere, for instance, of neutrality, between a just war and an unjust war. And nor was that development arrested with the adoption of the covenant of the League. The right of war was further circumscribed by a series of treaties numbering, it's an astonishing figure, but it's right, numbering nearly 1,000, of arbitration and conciliation embracing practically all the nations of the world. The so-called optional clause of Article 36 of the Statute of the Permanent Court of International Justice, the clause which conferred upon the court compulsory jurisdiction in regard to the most comprehensive categories of disputes, and which constituted in effect by far the most important compulsory treaty of arbitration, treaty of compulsory arbitration in the post-war period, was widely signed and ratified. Germany herself signed it in 1927. And her signature was renewed and renewed for a period of 5 years by the Nazi government in July of 1933. Significantly, that ratification was not again renewed on the expiration of its 5 years' validity in March of 1938. Not again renewed by Germany. Since 1928, a considerable number of states signed and ratified the General Act for the Pacific Settlement of International Disputes, which was designed to fill the gaps left by the optional clause and by the existing treaties of arbitration and conciliation. And all this vast network of instruments of Pacific settlement testified to the growing conviction throughout the civilized world that war was ceasing to be the normal or the legitimate means of settling international disputes. the express condemnation of wars of aggression, which I've already mentioned, supplies the same testimony. But there was, of course, more direct evidence pointing in the same direction. The Treaty of Locarno of the 16th of October 1925, to which I shall have occasion to refer presently and to which Germany was a party, was more than a treaty of arbitration and conciliation in which the parties undertook definite obligations with regard to the pacific settlement of disputes which might arise between them. It was subject to clearly specified exceptions of self-defense in certain contingencies, a more general undertaking in which the parties to it agreed that they would in no case attack or invade each other or resort to war against each other. And that constituted a general renunciation of war, and it was so considered to do in the eyes of the international jurists and in the public opinion of the world. The Locarno Treaty was not just another of the great number of arbitration treaties which were being concluded at this time. It was regarded as a kind of cornerstone in the European settlement and in the new legal order in Europe, in partial, just, and indeed generous substitution for the rigors of the Treaty of Versailles. And with that treaty, the term outlawry of war left the province of mere pacifist propaganda. It became current in the writings on international law and in the pronouncements, the official pronouncements of governments. No one could any longer say, after the Locarno Treaty, no one could any longer associate himself with the plausible assertion that, at all events, as between the parties to that treaty, war remained an unrestricted right of sovereign states. But although the effect of the Locarno Treaty was limited to the parties to it, it had a wider influence in paving the way towards that most fundamental, that truly revolutionary enactment in modern international law, namely the General Treaty for the Renunciation of War of the 27th of August 1928, the Pact of Paris, the Kellogg-Briand Pact. That treaty, a most deliberate and carefully prepared piece of international legislation, was binding in 1939 on more than 60 nations, including Germany. It was, and it has remained, the most widely signed and ratified international instrument. It contained no provision for its termination, and it was conceived, as I said, as the cornerstone of any future international order worthy of the name. It is fully part of international law as it stands today. It has been in no way modified or affected by or replaced by the Charter of the United Nations. And it's right in this solemn hour in the history of the world when the responsible leaders of a state stand accused of a premeditated breach of this great treaty, which was and which remains a source of hope and of faith for mankind, to set out in detail its two operative articles and its preamble. Now I read them to the tribunal. And first the preamble. And it starts like this. The President of the German Reich and the other states associated with it.
Shall we find it among the documents?
My Lord, it will be put in.
Oh, yes.
I don't think you have it at the moment.
Yeah.
The President of the German Reich, deeply sensible of their solemn duty to promote the welfare of mankind, persuaded that the time has come when a frank renunciation of war as an instrument of international policy should be made, to the end that the peaceful and friendly relations now existing between their peoples may be perpetuated, convinced that all changes in their relations with one another should be sought only by pacific means and be the result of a peaceful and orderly progress, and that any signatory power which shall hereafter seek to promote its national interests by resort to war should be denied the benefits furnished by this treaty. Encouraged by their example, all the other nations of the world will join in this humane endeavor, and by adhering to the present treaty as soon as it comes into force, bring their peoples within the scope of its beneficent provisions, thus uniting civilized nations of the world in a common renunciation of war as an instrument of their national policy. And then Article 1. The high contracting parties solemnly declare in the names of their respective peoples that they condemn recourse to war for the solution of international controversies and renounce it as an instrument of national policy in their relations with one another. And Article 2. The high contracting parties agree that the settlement or solution of all disputes or conflicts of whatever nature or whatever origin they may be, which may arise among them, shall never be sought except by pacific means. In that treaty, that general treaty for the renunciation of war, practically the whole civilized world abolished war as a legally permissible means of enforcing the law or of changing it. The right of war was no longer the essence of sovereignty. Whatever the position may have been at the time of the Hague Convention, whatever the position may have been in 1914, whatever it may have been in 1918, and it's not necessary to discuss it, no international lawyer of repute, no responsible statesman, no soldier concerned with the legal use of armed forces, no economist or industrialist concerned in his country's war economy could doubt that with the Pact of Paris on the statute book, a war of aggression was contrary to international law. Nor have the repeated violations of the Pact by the Axis powers in any way affected its validity. And let this be firmly and clearly stated. Those very breaches, except perhaps to the cynic and the malevolent, have added to the strength of the treaty. They provoked the sustained wrath of peoples, angered by the contemptuous disregard of this great statute and determined to vindicate its provisions. The Pact of Paris is the law of nations. This tribunal will declare it the world must enforce it. And let this also be said, that the Pact of Paris wasn't a clumsy instrument likely to become a kind of signpost for the guilty. It didn't enable Germany to go to war against Poland and yet rely, as against Great Britain and France, on any immunity from warlike action because of the very provisions of the Pact. For the Pact laid down expressly in its preamble that no state guilty of a violation of its provisions might invoke its benefits. And when, on the outbreak of the Second World War, Great Britain and France communicated to the League of Nations that a state of war existed between them and Germany as from the 3rd of September 1939, they declared that by committing an act of aggression against Poland, Germany had violated her obligations assumed not only towards Poland, but also towards the other signatories of the Pact. A violation of the Pact in relation to one signatory was an attack upon all the other signatories, and they were entitled to treat it as such. I emphasize that point, lest any of these defendants should seize upon the letter of the particulars of Count 2 of the indictment and seek to suggest that it was not Germany who initiated war with the United Kingdom and France on the 3rd of September 1939. The declaration of war came from the United Kingdom and from France. The act of war and its commencement came from Germany in violation of the fundamental enactment to which she was a party. The General Treaty for the Renunciation of War, this great constitutional instrument of an international society awakened to the deadly dangers of another Armageddon, didn't remain an isolated effort, soon to be forgotten in the turmoil of recurrent international crises. It became, in conjunction with the Covenant of the League of Nations, or independently of it, the starting point for a new orientation of governments in matters of peace, war, neutrality. It's of importance, I think, to quote just one or two of the statements which were being made by governments at that time in relation to the effect of that pact. In 1929, His Majesty's government said, in connection with the question of conferring upon the Permanent Court of International Justice jurisdiction with regard to the exercise of belligerent rights in relation to neutral states, said this, and it illustrates the profound change which was being accepted as having taken place as a result of the Pact of Paris in international law. But the whole situation rests, and international law on the subject has been entirely built up on the assumption that there is nothing illegitimate in the use of war as an instrument of national policy. And as a necessary corollary, that the position and rights of neutrals are entirely independent of the circumstances of any war which may be in progress. before the acceptance of the covenant, the basis of the law of neutrality was that the rights and obligations of neutral were identical as regards both belligerents and were entirely independent of the rights and wrongs of the dispute which had led to the war, or of the respective position of the belligerents at the bar of world opinion. And then the government went on. Now it is precisely this assumption which is no longer valid as regards states which are members of the League of Nations and parties to the Peace Pact. The effect of those instruments, taken together, is to deprive nations of the right to employ war as an instrument of national policy, and to forbid the states which have signed them to give aid or comfort to an offender. This was being said in 1929, when there was no war on the horizon. As between such states, there has been in consequence a fundamental change in the whole question of belligerent and neutral rights. The whole policy of His Majesty's present government, and it would appear of any alternative government, is based upon a determination to comply with their obligations under the covenant of the League and the Peace Pact. This being so, the situation which we have to envisage in the event of a war in which we were engaged is not one in which the rights and duties of belligerents and neutrals will depend upon the old rules of war and neutrality, but one in which the position of the members of the League will be determined by the covenant and by the pact. The Chief Prosecutor for the United States of America referred in his opening speech before this tribunal to the weighty pronouncement of Mr. Stimson, the Secretary of State, in which in 1932 he gave expression to the drastic change brought about in international law by the Pact of Paris. And it's perhaps convenient to quote the relevant passage in full. War between nations was renounced by the signatories of the Briand-Kellogg Pact. This means that it has become illegal throughout practically the entire world. It is no longer to be the source and subject of rights. It is no longer to be the principle around which the duties, the conduct, and the rights of nations revolve. It is an illegal thing. Hereafter, when two nations engaged in armed conflict, either one or both of them must be wrongdoers, violators of this general treaty law. We no longer draw a circle about them and treat them with the punctilios of the duelist's code. Instead, we denounce them as lawbreakers. And nearly 10 years later, when numerous independent states lay prostrate, shattered or menaced in their very existence before the impact of the war machine of the Nazi state, the Attorney General of the United States, subsequently a distinguished member of the highest tribunal of that great country, gave significant expression to the change which had been effected in the law as the result of the Pact of Paris. In a speech for which the freedom-loving peoples of the world will always be grateful, on the 27th of March of 1941. And I mention it now not as merely being the speech of a statesman, although it was certainly that, but as being the considered opinion of a distinguished lawyer. Said this: the Kellogg-Briand Pact of 1928, in which Germany, Italy, and Japan covenanted with us, as well as with other nations, to renounce war as an instrument of policy, made definite the outlawry of war and of necessity altered the dependent concept of neutral obligations. The Treaty for the Renunciation of War and the Argentine Anti-War Treaty deprived their signatories of the right of war as an instrument of national policy or aggression, and rendered unlawful wars undertaken in violation of their provisions. In consequence, these treaties destroyed the historical and juridical foundations of the doctrine of neutrality conceived as an attitude of absolute impartiality in relation to aggressive wars. It follows that the state which has gone to war in violation of its obligations acquires no right to equality of treatment from other states, unless treaty obligations require different handling of affairs. It derives no rights from its illegality. In flagrant cases of aggression, where the facts speak so unambiguously that world opinion takes what may be the equivalent of judicial notice, we may not stymie international law and allow these great treaties to become dead letters. The intelligent public opinion of the world, which is not afraid to be vocal, and the action of the American states has made a determination that the Axis powers are the aggressors in the wars today, which is an appropriate basis in the present state of international organization for our policy. Thus, there's no doubt that by the time the National Socialist state of Germany had embarked upon the preparation of the war of aggression against the civilized world, by the time it had accomplished that design, aggressive war had become, in virtue of the Pact of Paris and the other treaties and declarations to which I've referred, illegal and a crime beyond all uncertainty and doubt. And it is on that proposition, and fundamentally on that universal treaty, the Briand-Kellogg Pact, that count two of this indictment is principally based. Prosecution has deemed it necessary, indeed imperative, to establish beyond all possibility of question at what I'm afraid may appear to be excessive length, that only superficial learning or culpable sentimentality can assert that there is any significant element of retroactivity in the determination of the authors of this charter to treat aggressive war as conduct which international law has prohibited and stigmatized as criminal. We have traced the progressive limitation of the rights of war, the renunciation and condemnation of wars of aggression, and above all, the total prohibition and condemnation of all war conceived as an instrument of national policy. What statesman or politician in charge of the affairs of a nation or sharing in them could doubt from 1928 onwards that aggressive war, that all war, except in self-defense, or for the collective enforcement of the law, or against a state which had itself violated the Pact of Paris, was unlawful and outlawed? What statesman or politician embarking upon such a war could reasonably and justifiably count upon an immunity other than that of a successful outcome of the criminal adventure? What more decisive evidence of a prohibition laid down by positive international law could any lawyer desire than has been adduced before this tribunal? There are, it's true, some small-town lawyers who deny the very existence of any international law. And indeed, as I said, the rules of the law of nations may not satisfy the Austinian test of being imposed by a sovereign. But the legal relations, the legal regulation of international relations, perhaps that's a better way in which to put it, the legal regulation of international relations rests upon quite different juridical foundations. It depends upon consent, but upon a consent which, once given, cannot be withdrawn by unilateral action. In the international field, the source of law is not the command of a sovereign, but the treaty agreement binding upon every state which has adhered to it. And it is indeed true, and the recognition of its truth today by all the great powers of the world is vital to our future peace. It is indeed true that, as Monsieur Litvinov once said, and as Great Britain fully accepts, absolute sovereignty and entire liberty of action only belong to such states as have not undertaken international obligations. Immediately a state accepts international obligations, it limits its sovereignty. And that way alone, lies the future peace of the world. Yet it may be argued that although war itself was outlawed and forbidden, it wasn't criminally outlawed and criminally forbidden. International law, it may be said, does not attribute criminality to states and still less to individuals. But can it really be said on behalf of these defendants that the offense of these aggressive wars, which plunged millions of people to their deaths, which by dint of war crimes and crimes against humanity brought about the torture and extermination of countless thousands of innocent civilians, which devastated cities, which destroyed the amenities, the most rudimentary necessities of civilization in many countries, which has brought the world to the brink of ruin from which it'll take generations to recover, will it seriously be said by these defendants that such a war is only an offense, only an illegality, only a matter of condemnation, perhaps sounding in damages, but not a crime justiciable by any tribunal? no law worthy of the name can allow itself to be reduced to an absurdity in that way. And certainly the great powers responsible for this charter were not prepared to admit it. They drew the inescapable conclusion from the renunciation, the prohibition, the condemnation of war, which had become part of the law of nations. And they refused to reduce justice to impotence by subscribing to the outworn doctrine that the sovereign state can commit no crime and that no crime can be committed on behalf of the sovereign state by individuals acting as its agents. They refused so to stoutify themselves, and their refusal and their decision has decisively shaped the law for this tribunal. If this be an innovation, it is an innovation long overdue, a desirable, a beneficent innovation, fully consistent with justice, fully consistent with common sense, and with the abiding purposes of the law of nations. But is it? Is it indeed an innovation? Or is it no more than the logical development of the law? There was indeed a time when international lawyers used to maintain that the liability of a state, because of its sovereignty, was limited to a contractual responsibility. International tribunals have not accepted that view. They have repeatedly affirmed that a state can commit a tort, that it may be guilty of trespass, of nuisance, of negligence, and they've gone further. They have held that a state may be bound to pay what are in effect penal damages. In a recent case decided in 1935 between the United States and Canada, an arbitral tribunal, with the concurrence of its American member, decided that the United States were bound to pay what amounted to penal damages for an affront to Canadian sovereignty. And on a wider plane, the covenant of the League of Nations in providing for sanctions recognized the principle of enforcement of the law against collective units, such enforcement to be, if necessary, of a penal character. And so there's not anything startlingly new in the adoption of the principle that the state as such is responsible for its criminal acts. In fact, save for reliance on the unconvincing argument of sovereignty, there is in law no reason why a state should not be answerable for crimes committed on its behalf. And 100 years ago, Dr. Lushington, great English Admiralty judge, refused to admit that a state couldn't be a pirate. History, very recent history, doesn't warrant the view that a state cannot be a criminal. On the contrary, the immeasurable potentialities for evil inherent in the state in this age of science and organization would seem to demand, quite imperatively, means of repression of criminal conduct even more drastic and more effective than in the case of individuals. And insofar, therefore, as this charter has put on record the principle of the criminal responsibility of the state, it must be applauded as a wise and far-seeing measure of international legislation.
Would that be a convenient time to break
Yes,
off?
sir, that would be.
Bruno will rise for 10 minutes.
Saying before the recess that there could be no doubt about the principle of criminal responsibility on the part of a state which engaged in aggressive war. Admittedly, the conscience shrinks from the rigors of collective punishment, which may fall on the innocent and the guilty alike. Although it may be noted that most of the innocent victims would not have hesitated to reap the fruits of the criminal act if it had been successful. But humanity and justice will find means of mitigating any injustice of collective punishment. But above all, much hardship can be obviated by making the punishment fall upon the individuals who were themselves directly responsible for the criminal conduct of their state. And it is here that the powers who framed this charter took a step which justice, sound legal sense, and an enlightened appreciation of the good of mankind must acclaim without cavil or reserve. The Charter lays down expressly that there shall be individual responsibility for the crimes, including the crime against the peace, committed on behalf of the state. The state is not an abstract entity. Its rights and duties are the rights and duties of men. Its actions are the actions of men. It is a salutary principle, a principle of the law, that politicians who embark upon a particular policy, as here upon a policy of aggressive war, should not be able to seek immunity behind the intangible personality of the state. It is a salutary legal rule that persons who, in violation of the law, plunge their own and other countries into an aggressive war should do so with a halter around their necks. To say that those who aid and abet, who counsel and procure a crime, are in themselves criminal is a commonplace in our own municipal law. Nor is the principle of individual international responsibility for offences against the law of nations altogether new. It has been applied not only to pirates. The entire law relating to war crimes, as distinct from the crime of war, is based on the principle of individual responsibility. And the future of international law, and indeed of the world itself, depends on its application in a much wider sphere, and in particular in that of safeguarding the peace of the world. There must be acknowledged, not only as in the Charter of the United Nations, fundamental human rights, but also as in the Charter of this tribunal, fundamental human duties. And of these, none is more vital, none is more fundamental than the duty not to vex the peace of nations in violation of the clearest legal prohibitions and undertakings. If this be an innovation, It is an innovation which we are prepared to defend and to justify. But it is not an innovation which creates a new crime. International law had already, before the Charter was adopted, constituted aggressive war a criminal act. And there is thus no substantial retroactivity in the provisions of the Charter. It merely fixes the responsibility for a crime already clearly established as such by positive law upon its actual perpetrators. It fills a gap in international criminal procedure. There is all the difference in the world in saying to a man, you will now be punished for what was not a crime at all at the time you committed it, and in saying to him, you will now pay the penalty for conduct which was contrary to law and a crime when you executed it, although owing to the imperfection of international machinery, there was at that time no court competent to pronounce judgment against you. It is that latter course which we adopt, and if that be retroactivity, we proclaim it to be most fully consistent with that higher justice which in the practice of civilized states has set a definite limit to the retroactive operation of laws. Let the defendants and their protagonists complain that the Charter is in this matter an ex parte fiat of the victor. These victors, composing as they do the overwhelming majority of the nations of the world, represent also the world's sense of justice, which would be outraged if the crime of war after this second world conflict were to remain unpunished. In thus interpreting, declaring, and supplementing the existing law, these states are content to be judged by the verdict of history. Securus judicat orbis terrarum. Insofar as the charter of this tribunal introduces new law, its authors have established a precedent for the future, a precedent operative against all, including themselves. But in essence, the law rendering recourse to aggressive war an international crime was well established when this charter was adopted. It's only by way of a corruption of language that it can be described as retroactive law. There remains the question, on which I shan't detain the tribunal for long, whether these wars were launched by Germany and her leaders in violation of treaties, agreements, or assurances, were also wars of aggression. A war of aggression is a war which is resorted to in violation of the international obligation not to have recourse to war, or in cases in which war is not totally renounced, which is resorted to in disregard of the duty to utilize the procedure of pacific settlement which a state has bound itself to observe. There was, as a matter of fact, in the period between the two world wars, a divergence of opinion among jurists and statesmen whether it was preferable to attempt in advance a legal definition of aggression, or to leave to the states concerned and to the collective organs of the international community freedom of appreciation of the facts in any particular situation that might arise. And those holding the latter view argued that a rigid definition might be abused by an unscrupulous state to fit in with its aggressive design. They feared, and the British government was for a time amongst those who took this view, that an automatic definition of aggression might become a trap for the innocent and a signpost for the guilty. Others held that in the interest of certainty and security, a definition of aggression, like a definition of any crime in municipal law, was proper and useful. They urged that the competent international organs, political and judicial, could be trusted to avoid in any particular case a definition of aggression which might lead to obstruction or absurdity. And in May of 1933, the Committee on Security Questions of the Disarmament Conference proposed a definition of aggression on these lines. The aggressor in an international conflict shall, subject to the agreements in force between the parties to the dispute, be considered to be that state which is the first to commit any of the following actions. 1. Declaration of war upon another state. 2. Invasion by its armed forces, with or without a declaration of war, of the territory of another state. 3. Attack by its land, naval, or air forces, with or without a declaration of war, on the territory, vessels, or aircraft of another state. 4. Naval blockade of the coasts or ports of another state. 5. Provision of support to armed bands formed in its territory, which have invaded the territory of another state. Or refusal, notwithstanding the request of the invaded state, to take in its own territory all the measures in its power to deprive those bands of all assistance or protection. And the various treaties concluded in 1933 by the Union of Soviet Socialist Republics and other states followed closely on that definition. So did the draft convention submitted in 1933 by His Majesty's government to the Disarmament Conference. Unprofitable to elaborate here the details of the problem or the definition of aggression. This tribunal will not allow itself to be deflected from its purpose by attempts to ventilate in this court what is an academic and, in the circumstances here, an utterly unreal controversy as to the nature of what is a war of aggression. For there is no definition of aggression, general or particular, which does not cover and cover abundantly and irresistibly in every material detail the premeditated onslaught by Germany upon the territorial integrity and the political independence of so many sovereign states. This, then, being the law, as we submit it to this tribunal to be, that the peoples of the world, by the Pact of Paris, had finally outlawed war and made it criminal, I turn now to the facts to see how these defendants, under their leader and with their associates, destroyed the high hopes of mankind and sought to revert to international anarchy. And first let this be said, for it will be established beyond doubt by the documents which you will see. From the moment Hitler became Chancellor in 1933, with the defendant von Papen as Vice-Chancellor, with the defendant von Neurath as his Foreign Minister, the whole atmosphere of the world darkened. The hopes of the people began to recede. Treaties seemed no longer matters of solemn obligation, but were entered into with complete cynicism as a means for deceiving other states of Germany's warlike intentions. International conferences were no longer to be used as a means for securing pacific settlements, but as occasions for obtaining, by blackmail, demands which were eventually to be enlarged by war. The world came to know the war of nerves, the diplomacy of the fait accompli, of blackmail and bullying. In October 1933, Hitler told his cabinet that as the proposed disarmament convention did not concede full equality to Germany, it would be necessary, and I quote, "It would be necessary to torpedo the disarmament conference. It was out of the question to negotiate. Germany would leave the conference and the League." And on the 21st of October of 1933, Germany did so, and by so doing struck a deadly blow at the fabric of security which had been built up on the basis of the League covenant. From that time on, the record of their foreign policy became one of complete disregard of international obligations, and indeed, not least, of complete disregard of those very international obligations which had been solemnly concluded by themselves. Hitler himself expressly avowed to his confederates, agreements are kept only so long as they serve a certain purpose. He might have added that again and again, that purpose was only to lull an intended victim into a false sense of security. So patent, indeed, did this eventually become, that to be invited by the defendant Ribbentrop to enter into a non-aggression pact with Germany was almost a sign that Germany intended to attack the state concerned. Nor was it only the formal treaty which they used and violated as circumstances seemed to make expedient. These defendants are charged too with breaches of the less formal assurances which, in accordance with modern diplomatic usage, Germany gave to neighboring states. You will hear the importance which Hitler himself publicly attached to assurances of that kind. Today, with the advance of science, the world has been afforded means of communication and intercourse hitherto unknown, and as Hitler expressly recognized in his public utterances, international relations no longer depend upon treaties alone. The methods of diplomacy change. The leader of one nation can speak direct to the government and the peoples of another. And that course was not infrequently adopted by the Nazi conspirators. But although the methods change, the principles of good faith and honesty, established as the fundamentals of civilized society, both in the national and in the international sphere, remain unaltered. It's a long time since it was said that we are part one of another, and if today the different states are more closely connected and thus form part of a world society more than ever before, so also more than ever before is there that need of good faith and honesty between them. Let us see how these defendants, ministers and high officers of the Nazi government, individually and collectively comported themselves in these matters. On the 1st of September of 1939, in the early hours of the morning, under manufactured and in any event inadequate pretexts, the armed forces of the German Reich invaded Poland along the whole length of her frontiers and thus launched the war which was to bring down so many of the pillars of our civilization. It was a breach of the Hague Conventions. It was a breach of the Treaty of Versailles, which had established the frontier between Germany and Poland. And however much Germany disliked that treaty, although Hitler had expressly stated that he would respect its territorial provisions, however much she disliked it, she was certainly not free to break it by unilateral action. It was a breach of the arbitration treaty between Germany and Poland, concluded at Locarno on the 16th of October of 1925. By that treaty, Germany and Poland expressly agreed to refer any matters of dispute not capable of settlement by ordinary diplomatic machinery to the decision of an arbitral tribunal or of the Permanent Court of International Justice. It was a breach of the Pact of Paris. But that's not all. It was also a breach of a more recent, and in view of the repeated emphasis laid upon it by Hitler himself, in some ways a more important engagement into which Nazi Germany had entered with Poland. After the Nazi government came into power, On the 26th of January of 1934, the German and Polish governments had signed a 10-year pact of non-aggression. It was, as the signatories themselves stated, to introduce a new era into the political relations between Poland and Germany. It was said in the text of the pact itself that the maintenance and guarantee of lasting peace between the two countries is an essential prerequisite for the general peace of Europe. The two governments therefore agreed to base their mutual relations on the principles laid down in the Pact of Paris. And they solemnly declared, in no circumstances will they proceed to the application of force for the purpose of reaching a decision in such disputes. That declaration and agreement was to remain in force for at least 10 years. And thereafter, it was to remain valid unless it was denounced by either government 6 months before the expiration of the 10 years or subsequently by 6 months' notice. And both at the time of its signature and during the following 4 years, Hitler spoke of the German-Polish agreement publicly, as though it were a cornerstone of his foreign policy. By entering into it, he persuaded many people that his intentions were genuinely pacific, for the re-emergence of a new Poland, an independent Poland, after the war had cost Germany much territory and had separated East Prussia from the Reich, and that Hitler should of his own accord enter into friendly relations with Poland, that in his speeches on foreign policy he should proclaim his recognition of Poland and of her right to an exit to the sea, of the necessity for Germans and Poles to live side by side in amity. These facts seemed to the world to be convincing proof that Hitler had no revisionist aims which would threaten the peace of Europe, that he was even genuinely anxious to put an end to the age-old hostility between the Teuton and the Slav. If his professions, as embodied in the treaty and as contained in these declarations, were genuine, his policy excluded a renewal of the Drang nach Osten, as it had been called, and was therefore going to contribute to the peace and stability of Europe. That was what people were led to think. We shall have occasion enough to see how little truth these pacific professions in fact contain. The history of the fateful years from 1934 to 1939 shows quite clearly that the Germans used this treaty, as they had used other treaties, merely as an instrument of policy for furthering their aggressive aims. It is clear from the documents which will be presented to the tribunal that these 5 years fall into two distinct phases in the realization of the aggressive aims which always underlay the Nazi policy. There was first the period from the Nazi assumption of power in 1933 until the autumn of 1937. That was the preparatory period. During that time, there occurred the breaches of the Versailles and Locarno Treaties, the feverish rearmament of Germany, the reintroduction of conscription, the reoccupation and remilitarization of the Rhineland, and all those other necessary preparatory measures for future aggression, which my American colleagues have already so admirably put before the tribunal. During that period, the preparatory period, Germany was lulling Poland into a false sense of security. Not only Hitler, but the defendant Goering and the defendant Ribbentrop made statements approbating the non-aggression pact. In 1935, Goering was saying, I quote, that the pact was not planned for a period of 10 years, but forever. There need not be the slightest fear that it would not be continued. Even though Germany was steadily building up the greatest war machine that Europe had ever known, and although by January of 1937 the German military position was so strong and so secure that, in spite of the treaty breaches which it involved, Hitler could openly refer to his strong army. He took pains at the same time to say, and again I quote, that by a series of agreements we have eliminated existing tensions and thereby contributed considerably to an improvement in the European atmosphere. I merely recall the agreement with Poland, which has worked out to the advantage of both sides. And so it went on. Abroad, protestations of pacific intentions. At home, guns before butter. In 1937, this preparatory period drew to a close, and Nazi policy moved from general preparation for future aggression to specific planning for the attainment of certain specific aggressive aims. And there are two documents in particular which mark that change. The first of those was an important directive for unified preparation for war, as it was called, issued in June 1937, on June the 29th, 1937, by the Reich Minister for War, who was then von Blomberg, Commander-in-Chief of the Armed Forces. And that document is important not only for its military directions, but for the appreciation it contained of the European situation and for the revelation of the Nazi attitude towards it. The general political position, von Blomberg stated, I'm quoting now from the document, justifies the supposition that Germany need not consider an attack from any side. Grounds for this are in addition to the lack of desire for war in almost all nations, particularly the Western powers, the deficiencies in the preparedness for war of a number of states and of Russia in particular. He added, it is true, he added, the intention of unleashing a European war is held just as little by Germany. And it may be that that phrase was carefully chosen, because, as the documents will show, Germany hoped to conquer Europe, perhaps to conquer the world, in detail, to fight on one front at a time, against one power at a time, and not to unleash a general European conflict. But von Blomberg went on. The politically fluid world situation, which does not preclude surprising incidents, demands a continuous preparedness for war of the German armed forces. A, to counterattack at any time, yet he just said that there was no fear of any attack. And B, and I invite the tribunal again to notice this phrase, and B, to enable the military exploitation of politically favorable opportunities should they occur. That phrase is no more than a euphemistic description of aggressive war. It reveals the continued adherence of the German military leaders to the doctrine that military might, and if necessary, war, should be an instrument of policy. The doctrine which had been explicitly condemned by the Kellogg Pact, which was renounced by the pact with Poland and by innumerable other treaties. The document goes on to set out the general preparations necessary for a possible war in the mobilization period of 1937-38. It is evidence, at least for this, that the leaders of the German armed forces had in mind to use the military strength which they were building up for aggressive purposes. No reason, they say, to anticipate attack from any side. There is a lack of a desire for war, yet they prepare to exploit favorable opportunities. Still more important, as evidence of the transition to planned aggression, is the record of the important conference which Hitler held at the Reichschancellery on the 5th of November 1937, at which von Blomberg, the Reich Minister for War, von Fritsch, the Commander-in-Chief of the Army, Goering, the Commander-in-Chief of the Luftwaffe, Raeder, the Commander-in-Chief of the Navy, and von Neurath, then the Foreign Minister, were present. The minutes of that conference have already been put in evidence. I refer to them now only to emphasize those passages which make apparent the ultimate intention to wage an aggressive war. You will remember that the burden of Hitler's argument at that conference was that Germany required more territory in Europe. Austria and Czechoslovakia were specifically envisaged. But Hitler realized that the process of conquering those two countries might well bring into operation the treaty obligations of Great Britain
and of France. He was prepared to take the risk. You remember the passage. The history of all times, Roman Empire, British Empire, has proved that every space expansion can only be effected by breaking resistance and taking risks. Even setbacks are unavoidable. Neither formerly nor today has space been found without an owner. The attacker always comes up against the proprietor. The question for Germany is where the greatest possible conquest can be made at the lowest possible cost. In the course of that conference, Hitler had foreseen and discussed the likelihood that Poland would be involved if the aggressive, expansionist aims which he put forward brought about a general European war in the course of their realization by the Nazi state. And when, therefore, on that very day on which that conference was taking place, Hitler assured the Polish ambassador of the great value of the 1934 pact with Poland, it can only be concluded that its real value in Hitler's eyes was that of keeping Poland quiet until Germany had acquired such a territorial and strategic position that Poland was no longer a danger. That view is confirmed by the events which followed. At the beginning of February of 1938, the change from Nazi preparation for aggression to active aggression itself took place. It was marked by the substitution of Ribbentrop for von Neurath as foreign minister and of Keitel for Blomberg as head of the OKW. Its first fruits were the bullying of Schuschnigg at Berchtesgaden on February the 12th of 1938 and the forcible absorption of Austria in March. Thereafter, the Green Plan for the destruction of Czechoslovakia was steadily developed in the way that you heard yesterday. The plan partially foiled, or of which the final consummation was at least delayed by the Munich Agreement. With those aspects, those developments of Nazi aggression, my American colleagues have already dealt. But it is obvious that the acquisition of these two countries, their resources in manpower, their resources in the production of war, immensely strengthened the position of Germany as against Poland. And it's therefore perhaps not surprising that just as the defendant Goering assured the Czechoslovak minister in Berlin at the time of the Nazi invasion of Austria that Hitler recognized the validity of the German Czechoslovak Arbitration Treaty of 1925, and that Germany had no designs against Czechoslovakia herself. You remember? I give you my word of honor, the defendant Goering said. Just as that is not surprising, so also it is not perhaps surprising that continued assurances should have been given during 1938 to Poland in order to keep that country from interfering with the Nazi aggression upon Poland's neighbors. Thus, on the 20th of February of 1938, on the eve of his invasion of Austria, Hitler, referring to the fourth anniversary of the Polish Pact, permitted himself to say this to the Reichstag. And I quote, "And so a way to a friendly understanding has been successfully paved, an understanding which, beginning with Danzig, has today succeeded in finally taking the poison out of the relations between Germany and Poland, and transforming them into a sincere, friendly cooperation. Relying on her friendships, Germany will not leave a stone unturned to save that ideal which provides the foundation for the task ahead of us, peace." Still more striking, perhaps, are the cordial references to Poland in Hitler's speech in the Sportplatz at Berlin on the 26th of September of 1938. He then said, "The most difficult problem with which I was confronted was that of our relations with Poland. There was a danger that Poles and Germans would regard each other as hereditary enemies. I wanted to prevent this. I know well enough that I should not have been successful if Poland had had a democratic constitution. For these democracies which indulge in phrases about peace are the most bloodthirsty war agitators. In Poland there ruled no democracy but a man, and with him I succeeded in precisely 12 months in coming to an agreement which for 10 years in the first instance entirely removed the danger of a conflict. We are all convinced that this agreement will bring lasting pacification. We realize that here are two peoples which must live together, and neither of which can do away with the other. A people of 33 millions will always strive for an outlet to the sea. A way for understanding then had to be found, and it will be further extended. Certainly things were hard in this area, but the main fact is that the two governments and all reasonable and clear-sighted persons among the two peoples and in the two countries possess the firm will and determination to improve their relations. It was a real work of peace, of more worth than all the chattering in the League of Nations palace at Geneva. And so, flattery of Poland preceded the annexation of Austria, and renewed flattery of Poland preceded the projected annexation of Czechoslovakia. The realities behind these outward expressions of goodwill are clearly revealed in the documents relating to the Fall Grün, which are already before the tribunal. They show Hitler as fully aware that there was a risk of Poland, England, France being involved in war to prevent the German annexation of Czechoslovakia, and that this risk although it was realized, was also accepted. On the 25th of August of 1938, top secret orders to the German Air Force in regard to the operations to be conducted against England and France, if they intervened, pointed out that as the Franco-Czechoslovak Treaty provided for assistance only in the event of an unprovoked attack, it would take a day or two for France and England, and I suppose the lawyers, to decide whether legally the attack had been unprovoked or not. And consequently, a blitzkrieg, accomplishing its aims before there could be any effective intervention by France or by England, was the object to be aimed at. On the same day, an Air Force memorandum on future organization was issued, and to it there was attached a map on which the Baltic states, Hungary, Czechoslovakia, and Poland were all shown as part of Germany, and preparations for expanding the Air Force, and I quote, "as the Reich grows in area," as well as dispositions for a two-front war against France and Russia, were discussed. And on the following day, von Ribbentrop was being minuted about the reaction of Poland towards the Czechoslovak problem. I quote, "The fact that after the liquidation of the Czech question, it will be generally assumed that Poland will be next in turn is recognized, but it's stated, the later this assumption sinks in, the better." I'll pause for a moment at the date of the Munich Agreement and ask the tribunal to remind itself of what the evidence of documents and historical facts shows up to that date. It has made undeniable both the fact of Nazi aggressiveness and of active and actual aggression. Not only does that conference of 1937 show Hitler and his associates deliberately considering the acquisition of Austria and Czechoslovakia, if necessary, by war, but the first of the operations had been carried through in March of 1938, and a large part of the second, under threat of war, a threat as we now see which was much more than a bluff, a threat of actual and real war, although without the actual need for its initiation, secured, as I say, a large part of the second objective in September of 1938. And more ominous still, Hitler had revealed his adherence to the old doctrines of Mein Kampf, those essentially aggressive doctrines to the exposition of which in Mein Kampf, long regarded as the Bible of the Nazi Party, we shall draw attention in certain particular passages. Hitler is indicating quite clearly to not only to his associates, but indeed to the world at this time, that he is in pursuit of Lebensraum and that he means to secure it by threat of force, or if threat of force fails, by actual force and by aggressive war. So far, actual warfare had been avoided because of the love of peace, the lack of preparedness, the patience, the cowardice, call it what you will, of the democratic powers. But after Munich, the questions which filled the minds of all thinking people with acute anxiety was, where will this thing end? Is Hitler now satisfied, as he declares himself to be? Or is his pursuit of Lebensraum going to lead to further aggressions, even if he has to embark on open, aggressive war to secure it? It was in relation to the remainder of Czechoslovakia and to Poland that the answer to these two questions was to be given. So far, up to the time of the Munich Agreement, no direct and immediate threat to Poland had been made. The two documents from which I've just quoted show, of course, that high officers of the defendant Goering's air staff had already regarded the extension of the Reich and, it would seem, the destruction and the absorption of Poland as a foregone conclusion. They were already anticipating, indeed, the last stage of Hitler's policy as expounded in Mein Kampf, war to destroy France and to secure Lebensraum in Russia. And the writer of the minute to von Ribbentrop already took it for granted that after Czechoslovakia, Poland would be attacked. But more impressive than those two documents is the fact that, as I've said at the conference of November the 5th of 1937, war with Poland, if she should dare to prevent German aggression with Czechoslovakia, had been quite coolly and calmly contemplated, and the Nazi leaders were ready to take the risk. So also had the risk of war with England and France under the same circumstances been considered and accepted. As I indicated, such a war would, of course, have been an aggressive war on Germany's part, and they were contemplating an aggressive war. For to force one state to take up arms to defend another state against aggression in order to fulfill its treaty obligations is to initiate aggressive warfare against the first state. But in spite of those plans, in spite of these intentions behind the scenes, it remains true that until Munich, the decision for direct attack upon Poland and her destruction by aggressive war had apparently not yet been taken by Hitler and his associates. It is to the transition from the intention and preparation of initiating an aggressive war, evident in regard to Czechoslovakia, to the actual initiation and waging of aggressive war against Poland that I now pass. And that transition occupies the 11 months from October the 1st of 1938 to the actual attack on Poland on the 1st of September of 1939. Within 6 months of the signature of the Munich Agreement, the Nazi leaders had occupied the remainder of Czechoslovakia, which by that agreement they had indicated their willingness to guarantee. On the 14th of March 1939, the aged and infirm president of the rump of Czechoslovakia, Pasha, and his foreign minister were summoned to Berlin. At a meeting held between 1 o'clock and 2:15 in the small hours of the 15th of March, in the presence of Hitler, of the defendants Ribbentrop, Goering, and Keitel, they were bullied and threatened and bluntly told that Hitler had issued the order for the German troops to move into Czechoslovakia and for the incorporation of Czechoslovakia into the German Reich. It was made quite clear to them that resistance would be useless and would be crushed by force of arms, I quote, would be crushed by force of arms with all available means. And it was thus that the Protectorate of Bohemia and Moravia was set up, and that Slovakia was turned into a German satellite, although nominally independent state. By their own unilateral action, on pretexts which had no shadow of validity, without discussion with the governments of any other country, without mediation, in direct contradiction of the sense and the spirit of the Munich Agreement, the Germans acquired for themselves that for which they had been planning in September of the previous year, and indeed much earlier, but which at that time they had felt themselves unable completely to secure without too patent an exhibition of their aggressive intentions. Aggression achieved whetted the appetite for aggression to come. There were protests. England and France sent diplomatic notes. Of course there were protests. The Nazis had clearly shown their hand. Hitherto they had concealed from the outside world that their claims went beyond incorporating into the Reich persons of German race living in bordering territory. Now, for the first time, in defiance of their solemn assurances to the contrary, non-German territory and non-German peoples had been seized. This acquisition of the whole of Czechoslovakia, together with the equally illegal occupation of the Memel land on the 22nd of March 1939, resulted in an immense strengthening of the German position, both politically and strategically, as Hitler had anticipated it would when he discussed the matter at that conference in November of 1937. But long before the consummation by the Nazi leaders of their aggression against Czechoslovakia, they had begun to make demands upon Poland. The Munich settlement achieved, on the 25th of October 1938, that is to say, within less than a month of Hitler's reassuring speech about Poland, to which I've already referred, and within, of course, a month of the Munich Agreement, Monsieur Lipski, the Polish ambassador in Berlin reported to Monsieur Beck, the Polish foreign minister, that at a luncheon at Berchtesgaden the day before, that's to say on October the 24th, 1938, the defendant Ribbentrop had put forward demands for the reunion of Danzig with the Reich and for the building of an extraterritorial motor road and railway line across Pomorze. That is the province which the Germans call the corridor. From that moment onwards, until the Polish government had made it plain, as they did do during a visit of the defendant Ribbentrop to Warsaw in January 1939, that they would not consent to hand over Danzig to German sovereignty, negotiations on these German demands continued. And even after Ribbentrop's return from the visit to Warsaw, Hitler thought it worthwhile, in his Reichstag speech on the 30th of January 1939, to say, "We have just celebrated the 5th anniversary of the conclusion of our non-aggression pact with Poland. There can scarcely be any difference of opinion today among the true friends of peace as to the value of this agreement. One only needs to ask oneself what might have happened to Europe if this agreement, which brought such relief, had not been entered into 5 years ago. In signing it, the great Polish marshal and patriot rendered his people just as great a service as the leaders of the National Socialist state rendered the German people. During the troubled months of the past year, the friendship between Germany and Poland has been one of the reassuring factors in the political life of Europe. But that utterance was the last friendly word from Germany to Poland, and the last occasion on which the Nazi leader mentioned the German-Polish agreement with approbation. During February 1939, silence fell upon German demands in relation to Poland. But as soon as the final absorption of Czechoslovakia had taken place and Germany had also occupied Memel, Nazi pressure upon Poland was at once renewed. In 2 conversations between himself and the defendant Ribbentrop, held on the 21st of March and the 26th of March respectively, with the Polish ambassador, German demands upon Poland were renewed and were further pressed. And in view of the fate which had overtaken Czechoslovakia, in view of the grave deterioration in her strategical position towards Germany, it's not surprising that the Polish government took alarm at the developments. Nor were they alone in the matter. The events of March 1939 had at last convinced both the English and the French governments that the Nazi designs of aggression were not limited to men of German race, and that the spectre of European war resulting from further aggressions by Nazi Germany had not, after all, been exorcised by the Munich Agreement. And as a result, therefore, of the concern of Poland and of England and of France at the events in Czechoslovakia and at the newly applied pressure on Poland, conversations between the English and Polish governments had been taking place. And on the 31st of March of 1939, Mr. Neville Chamberlain, speaking in the House of Commons, stated that His Majesty's government had given an assurance to help Poland in the event of any action which clearly threatened Polish independence and which the Polish government accordingly considered it vital to resist. On the 6th of April 1939, an Anglo-Polish communique stated that the two countries were prepared to enter into an agreement of a permanent and reciprocal character to replace the present temporary and unilateral assurance given by His Majesty's government. And the justification for that concern on the part of the democratic powers was not difficult to find. With the evidence which we now have of what was happening within the councils of the German Reich and its armed forces during these months, it is manifest that the German government were intent on seizing Poland as a whole, that Danzig, as Hitler was himself to say in terms a month later, was not the subject of the dispute at all. The Nazi government was intent upon aggression, and the demands and negotiations in respect of Danzig were merely a cover and an excuse for further domination. Would that be a convenient moment?
We'll adjourn now until 2 o'clock.